ahead and get started. I appreciate everybody joining us today for this week's podcast related to estate planning and planning for your future. What we do is talk about topics that relate to specifics on planning and understanding the need for planning and how to do it properly. Today, we're going to be talking a little bit about the complexities inside of a revocable living trust. A lot of times, people think that when you do a trust, all trusts are the same. And sometimes, depending on who you work with, that can be true. There's, a template and everybody gets the same thing. But the reality is that a trust can be structured in hundreds, even thousands of different ways. And the way you structure your trust needs to be customized to your personal family situation and needs. And so the whole purpose of doing the planning is to make sure that whatever your intentions are after you're gone, those are the things that are going to be honored, as part of your plan. And so, when we set up a trust, one of the things we want to consider is what are the family dynamics that you have for the beneficiaries or the individuals that are going to be receiving any of the assets or the benefits of the trust. And let me share a story with you. So we had a situation where there was 4 beneficiaries in a trust. And unfortunately, we hadn't set up the trust, but this family had 4 of the children, and they got along normally pretty well. But one of the children was a severe alcoholic and had issues with debts, and basically anytime he received any money, he would misspend the money and it would be gone, pretty quick. And so the other siblings didn't want to give him his share of the estate because they knew that he was just going to misspend it and it wouldn't really serve him properly. It's a situation that we call spendthrifts. And so if there's an individual that's not good with money or maybe has debtor problems or gambling problems or drug problems or alcohol problems, we call those individuals spendthrifts, and we need to protect them from themselves. Unfortunately, in this trust, there was no provisions allowing for that. So we had to get his permission to set aside the money for him so that he wouldn't have direct access. Well, it's a lot harder conversation than if we were to build it into the trust. So one of the things that we can do in situations where there's a beneficiary like that, or any situation where maybe we don't want the individual to receive the money directly. Like, for example, if you have a special needs child, you don't want that money received directly by the beneficiary because it can disqualify them from benefits that they would otherwise be entitled to. And we don't want to affect their benefits negatively. So there's other situations that may require this as well. But basically what we do is we create a trust within a trust. It's called a subtrust. And within the terms of your trust document, you can actually dictate what's supposed to happen with that share that's going to go to the beneficiary or the child or the individual that has a problem with the money or with, losing benefits or whatever the case may be. We get to decide who's going to control that for them. We also get to decide what are the terms that they're going to benefit from it. So, for example, in this case, if we would have set up a subtrust, we would have said, okay, this is not to provide for, drugs or alcohol or any of those, lavish expenses that he may want, but it is to provide for medical care. It's to provide for, living conditions and making sure that he has a comfortable place to live, making sure that he has, food and clothing and those sort of things, right? Or we can make it more specific. We can specifically say, and we do this often, for most trusts, if you have minor children, we can say, well, this money's for college, or this money's for, setting up a business, or this money's for being able to purchase your first home. Or if you get married, there's a certain amount of money available for that, right? So we can build in whatever conditions, whatever guidelines that you want in your trust plan, and we do it through these sub-trusts. So a lot of times, people get confused when, parents left a trust and then there's 4 kids and the trust splits into 4 different shares for each of the kids with a sub-trust for each child. And the question is, well, do we need to go set up a new trust for each of these children? Because in the trust, it says that they're going to receive it in trust. But all that means is that the trust document itself, the original document, it already created those subtrusts. So you don't have to go and do a new document to have a subtrust. It's already created. It's part of the plan. And so the first trust eventually will dissolve, and then the trust for the beneficiaries will take over. And in the trust, you can decide who's going to be in charge of each of those shares, and what are the terms and what are the conditions for each of those shares. And the idea of the subtrust is that it provides not only a lot of control, that you can decide what you want to have happen with the legacy that you're leaving to your loved ones, but it also gives you the ability to provide specific guidance and direction and that sort of thing, but also to provide protection. So we talked about one example of protection in the case of, maybe a beneficiary not needing to receive the assets directly because it could cause problems for them. Another form of protection is, we get this question a lot where clients will say, okay, well, I have a son or I have a daughter and they're not married yet. But if they get married, I want to make sure that, their inheritance stays just for them. I don't want it to go to some spouse that I don't know. Maybe they're not good for them. Maybe they end up getting a divorce. Maybe they have, problems in their marriage. I don't want the spouse to end up with the inheritance that I leave for my child. So how do we do that? And you do it the same way. You do it through your subtrust, because your subtrust allows you to protect whatever you leave for the beneficiary from creditors, from lawsuits, from divorces, from, any of those sort of things that can negatively affect the assets that are left, as long as they keep it in trust. So when they receive the subtrust or the assets in the subtrust, that is going to transfer to them in a specific account that, as long as they keep it in there, then it'll be protected from any of those sort of claims. And that can be a powerful thing. And, it's also a powerful thing in the case that if you happen to have a situation where there is a creditor trying to collect from your personal assets, or you are going through a divorce, and all of a sudden you receive this windfall, that it doesn't negatively affect your financial situation, because your inheritance is kept completely separate from you as long as it's in trust. And then again, depending on how we structure the trust, the beneficiary themselves, the child, they can be their own trustee, or you can have somebody else be the trustee for them. And there may be instances where that makes more sense than having them in control of their own money. So one of the subtrusts that we do very commonly is for minor children. If you have minor children, we don't necessarily want everything divided right away into equal shares for the kids, because what if one of the kids, if they're still minors, we want to make sure that they're taken care of, that the trust is providing for them adequately, right? And so here's an example. If somebody leaves a revocable living trust, and let's say they have some life insurance, they have a modest home, their value of the estate is maybe $1 million, right? So let's say there's $1 million, and there's 3 children. One of the children is 19, and the other 2 are, 14 and 7, right? If we don't have what's called a common trust, or a pool trust, or, there's different ways that we can name it, children's trust within the trust. If we don't have these provisions in there, then what would happen immediately is that the shares that are left for each of the children would have to be split into their own separate trust, right? So that would create a subtrust for, the 19-year-old, a subtrust for the 14-year-old, and a subtrust for the 7-year-old. But maybe, out of that $1 million, part of it's a home, right? In order to split it equally, maybe the home would have to be sold. And if the 19-year-old wants their money right away, because nobody's managing it for them, they're over, the age of 18, they're an adult, And if the trust doesn't have any provisions saying that they can't, then, they're going to be in charge of their own money. Then they say, okay, well, I want my share. I want my third. So the house has to be sold. Well, the 7-year-old and the 14-year-old are still living in the house. And maybe there's not another home to have them in, right? And there's, depending on where you live, maybe not enough money to buy a new home. And so those are issues that can come up. So what we do is we set up a common trust, which basically says until the youngest child reaches a certain age, this is all going to be held together in one pool. And it's going to be used to benefit all the children and to take care of them. But we're going to prioritize taking care of the younger children who are underage until they reach, let's say, age 18. After they reach age 18, then there's less of a need to prioritize taking care of them. So then it can be split into equal shares, whatever's left. And when it gets split in equal shares, then we can still build in those sub-trusts with guidelines and provisions and instructions for each of their shares if we want to. So that's a very common feature that we end up putting into plans. And I think a lot of families would benefit from having a common trust in their estate plan, but a lot of times they don't even know that it's an option, right? And so particularly where there's a big age gap between the children, common trust is a very good idea. And, the thing to remember is that as much as you would like to make sure that everything is fair and equal, fair is not always equal, and equal is not always fair, right? And so whatever your sense of fairness or equality is that you want to leave for your children or for your beneficiaries, that needs to be reflected in your planning. And making sure that, obligations to younger children, minors, are taken care of. I think, most families would agree that that's probably a priority. And maybe even prioritizing beyond turning 18, right? Making sure that they go to college or making sure that they have, a good handle on being able to be independent in life. That can all be built into your plan. So the sub-trust in estate planning is a very important tool. And if you don't do customized estate planning, you probably don't have sub-trusts built into your plan. If you've done like a cookie cutter template sort of trust, it will probably say something like, the rest of the assets will be left equally to my children, outright and free of trust. Outright and free of trust means that they just receive it themselves and they have no protection from creditors, from lawsuits, from divorces, or anything like that. They have 100% control as soon as they turn 18 over that money, and they can do whatever they want with it without restrictions, unless the trust imposes further restrictions. And because it's outright and free of trust, if unforeseen circumstances come up where those protections could be valuable or useful, there's not a way for the trustee to change that. So our default for most plans when we do customized planning with our clients is to include a sub-trust, even if it's just a general needs trust with 100% right of withdrawal. That still gives all the flexibility that the beneficiary needs to be able to access and use and do whatever they need to with the money. But it provides them with those protections. And it provides the trustee with flexibility, because if there's unforeseen circumstances that come up, and all of a sudden, one of the children says, hey, I do want my money, but I have a debt that, I'm going to court for, and I don't want them to just take all of my inheritance. What can we do about it? And the trustee can choose to say, okay, well, we won't give you direct access to that money yet, so that way the creditor won't take it, right? So giving your trustee flexibility, as long as it's a trustee that you can trust, and to be honest, you would never choose a trustee that you don't, is a good thing. And so that's what we wanted to cover today, is the idea of going a little bit deeper into your living trust plans and the purpose for why you would want to do that. So at this point, we're going to open it up. Anybody who's on with us today, if you have any questions you want to submit through the chat, or if you want to raise your hand and we can try to unmute you, then we can address a couple questions before we wrap up for the day. Only a small percentage of our listeners are actually subscribed, so make sure you hit that subscribe button and catch up on all of our latest podcasts.